Hello, my name is Nathan Jones and I'm a Senior Associate in McCabe Curwood's Litigation and Dispute Resolution Group. Today I'll be talking briefly about caveatable interests. Caveat is a Latin expression which means, literally, let a person beware. Under property law, caveat has a very specific meaning. It refers to completing an approved form and submitting it to the Registrar General, which regulates the land title system. If the caveat is accepted, it appears on the publicly available title to the relevant property, thus serving as a warning to anyone who may be considering dealing with that property that someone claims to have an interest in it. The party who lodges the caveat is referred to as the caveator. Section 74F of the Real Property Act 1900, New South Wales, entitles any person who claims to have, open quotes, a legal or equitable estate or interest in land, close quotes, to lodge a caveat against the title. This is what is meant by a caveatable interest, which is also referred to as a proprietary interest. In the recent decision of Tarlee Investment Pty Ltd and Antonios, the New South Wales Court of Appeal confirmed that whilst granting a party a caveatable interest in a contract is a relatively simple thing to do with the right wording, it can also be very easy to get wrong if not careful. A company called MV Developments borrowed $1.5 million from another company, Tarlee, to develop certain land into an apartment block. The loan was recorded in a deed, clause 7.2 of which specified the consequences of an event of default to include, open quotes, lodge and maintain a caveat until such time as the lender receives full payment, close quotes. After MV Developments defaulted on the loan, Tarlee lodged a caveat against the title of one of the apartments which had been built. The interest that Tarlee claimed in relation to the property was an equitable charge. A dispute arose when another party contended that he had entered into a contract with MV Developments to purchase this particular apartment. The New South Wales Court of Appeal rejected Tarlee's argument that a contractual right to lodge a caveat carried with it, by implication, the grant of an equitable charge which would support a caveat. Rather, the Court of Appeal held, whether a clause in a contract creates a caveatable interest depends on the proper construction of, or meaning conveyed by, the document taken as a whole. The Court of Appeal concluded that the deed, on its proper construction, did not create a caveatable interest in favour of Tarlee. The Court of Appeal stated at paragraph 104, open quotes, there is no reference to security, secured interest, charge, caveatable interest, or any other language which would point to Tarlee having an equitable interest. Had the parties intended for Tarlee to have a secured interest, the deed could have said so, and it is to be expected that it would have made express provision to that effect. Close quotes. Accordingly, Tarlee's appeal was dismissed with costs. What can we learn from this case? A few things. Firstly, a contractual right to lodge a caveat will not necessarily give rise to a caveatable interest. Further, the language of the contract must point to the caveator having, open quotes, a legal or equitable estate or interest in land, close quotes, for example, by giving that party an express right to an equitable charge. Finally, the drafters of the contract need to be careful to ensure that the existence of a caveatable interest is not contradicted by any language or express term found elsewhere in the document. McCabe Curwood has extensive experience in matters involving lodgement of caveats and interests in land, as well as property disputes generally. If you would like to read more about this particular case, please visit our website.